This week on the Backtable Podcast.
I had my first surprise employment issue, which, the thing about these things is they usually blindside you. And the first and maybe second time it happens, you don't know what to do, or you feel blindsided, or, this is not a topic that doctors know a lot about. So you don't know what to do. And it turns out when you have a competent attorney swoop in and, take it over from there. I kind of liken it to, you hear the words, you have a mass and you've been diagnosed with cancer. Well, you can't expect that patient then to know everything about, stage 4 colon cancer they've just been diagnosed with. And it's the same with law. You have these employment issues and lawyers happen to be really good and have heard it all before. So good attorneys are the answer to that.
Yeah, for sure. And how did you guys meet each other?
Courtney saved me one day. She pulled me out of the fetal position and gave me my life back. And we've been friends ever since.
Hello, everybody. Welcome to the Backtable Podcast, your source for all things IR and endovascular. I am very excited to introduce our guests and the topic for today. But first, a quick word from our sponsor, RadPad. RadPad was developed by physicians for physicians, clinically proven radiation protection during cine and digital subtraction angiography. Don't bet your career or your health on anything less. Trust RadPad radiation protection shields for all your fluoro-guided interventions. See radpad.com for more information. Contact info@radpad.com for a free radiation evaluation and a no-brainer radiation protection cap. And when you contact them, please let them know you heard about it on the Backtable Podcast. And today I am, real quick, Mary, do you happen to use anything for radiation protection? Do you use the RadPad stuff, or have you ever?
No, I haven't. In fact, now doing all of my cases radially, I'm always worried about the left side of my body. In fact, I'm wondering when I'm going to get my left-sided osteosarcoma. So from the groin, I worried about it less. I've never used RadPad. And now, doing radial, I don't even have a shield. So
yeah, well, you know what, they will come and do a free radiation evaluation and kind of figure out how to help reduce your radiation if you're interested. So
yeah, that would be great. Even the lead that I got, it turns out the arm shield on the lead is just the upper shoulder, and I really need my forearm and hand to be better protected. So it's a great idea.
Okay, cool. Well, I'll send you their information. So anyway, let's get right into it. I'm very happy to introduce our guest and topic for today. We're going to talk a little bit about physician contracts, which is, I think, would be a great topic for young IRs coming out of fellowship, or even seasoned IRs who are changing jobs, or maybe doing something different. Today we have Mary Costantino returning as a guest. We're happy to have her back. She's bringing on special guest Courtney Angeli, who is an employment lawyer. Courtney, can you tell us a little bit about yourself and your background?
Sure. I've been a lawyer for about 25 years, and I've been doing employment law specifically for the vast majority of that time. My practice has been somewhat unusual in that most people represent either individuals or employers. And over the course of my career, I've actually done both. The first 15 years of my career, I did exclusively employer work, and I have represented a number of hospital and physician groups in that part of my career. And then about 10 years ago, I started representing individual employees as well as continuing my employer work. So I have, in the past decade, represented a fair number of individual physicians who are either changing practices or going into practice for the first time, with all kinds of different arrangements, for who they're going to work for.
Okay, great. And we've got tons of questions for you here. about this. Real quick, Mary, for the uninitiated who maybe haven't heard your prior podcast or as familiar with your work on the SIR forum, I can just give a little bit of background.
Oh, sure. Well, mine's less interesting. I have an interventional radiologist, and I started a OBL that I now call a vascular center. We opened about 4 months ago. I've been working on it for about 2 years. I've been in one city since 2002 and have had 3 or 4 jobs, which is why I have had so much interface with an employment attorney. And now having a number of years of having to deal with attorneys underneath my belt, I wouldn't say having to deal with them, having the pleasure of working in collaboration with attorneys. I have had experience in that realm. I never thought I would have it. When I came out of fellowship, you always think you're going to have one job and everybody's going to always be happy, but it doesn't turn out to be the case. So, and definitely owning my own practice and having partners, it can get complicated. Relationships can be complicated. So good attorneys are the answer to that.
Yeah, for sure. And how did you guys meet each other?
Courtney saved me one day. She pulled me out of the fetal position and gave me my life back. And we've been friends ever since. I was married to an attorney, and I had my first surprise employment issue, which, the thing about these things is they usually blindside you. And the first and maybe second time it happens, you don't know what to do, or you feel blindsided, or, this is not a topic that doctors know a lot about. So you don't know what to do. And it turns out when you have a competent attorney swoop in and, take it over from there. I kind of liken it to, you hear the words, you have a mass and you've been diagnosed with cancer. Well, you can't expect that patient then to know everything about, stage 4 colon cancer they've just been diagnosed with. And it's the same with law. You have these employment issues and lawyers happen to be really good and have heard it all before. So Courtney has saved me. And
one of the nice things about my practice is that I often do become friends with people that I consult with. And so that's fun. And I get to see into, every different industry, basically.
Courtney, what I want to ask you about next is, from a healthcare lawyer perspective, are you seeing any recent trends in physician contracts, people, getting into these big groups, dealing with employment contracts, or, more independent physicians coming across your plate? Are you seeing any trends recently?
Yeah, there's definitely some trends. I mean, one thing I've noticed since the beginning of my career is that in many professions, people go into their work relationship just on a handshake or a verbal agreement. And, that can certainly be enforceable. That may be an enforceable agreement, even if it's not a written agreement. There seems to have been in the physician culture for a long time just a sort of habit or expectation of there being formal written contracts. And I don't know how that came about, but it's definitely something I've seen as the absolute norm. I don't know that I've ever encountered a physician who doesn't have a written contract. So that has continued. As you all are probably more keenly aware than I am, the whole marketplace of work has been undergoing greater and greater consolidation, with larger organizations swallowing up smaller organizations. So I'd say earlier in my career, there were a lot more little doctors' practice groups, and more we see those being, gobbled up by big hospitals or larger providers. And so it seems like there's a lot fewer couple of doctors working together on a corner and a lot more people working in larger organizations. So that has had some implications, mostly for, I'd say there's probably fewer partnership type agreements and more people who are physicians working as employees of larger healthcare providers. I think there's an increasing emphasis on what the doctor's formal legal status is in relation to the organization that he or she works for, and we can talk about that in detail in a bit, but whether or not they're a partner, are they an employee, are they a shareholder of a PC, of a professional corporation, and if they are they properly characterized? There's all kinds of issues there that we can talk about. A big, I think, issue that's hitting a lot of industries, particularly with I don't know, stuff going on with sex harassment and that sort of thing, is arbitration agreements. I think law, and there's a lot of similarities between the profession of law and the profession of medicine. And in the past, you didn't see a lot of lawyers suing law firms, and you didn't see a lot of female physicians suing doctors groups. I think a lot of that has changed. And so there's more and more consideration being given to arbitration agreements, which means you wouldn't have a publicly filed dispute. It would be confidentially resolved through a more private channel of arbitration. So I think I'm seeing more agreements that have arbitration provisions come across my desk.
Gotcha. And we're gonna get into non-competes later, but is that kind of fall into that?
Non-competes are kind of all over the map. So one thing I should make clear from the beginning is I'm sort of talking about the law generally, because all of these issues, they're really governed by state law. So we happen to be here in Oregon, and what makes a contract is going to be a little bit different under an Oregon law analysis than a Washington state law analysis, than a Texas law analysis. There's differences in non-compete laws. For example, in California, there's actually a prohibition on them. Oregon has certain conditions that have to be met before they're enforceable. And, Washington, presently, they're fully enforceable, but I think Washington's going to do a significant ban on them. I think that's working its way through the legislature. So, whatever you hear from me today is going to be somewhat variable depending on state law, but I haven't seen such huge variations in different states' laws on these topics that you can't get the same broad brush, or you can't derive the broad brushstrokes of your state, based on some other experience in another state.
Yeah, well, that's interesting. I hadn't heard that there's a prohibition in California and soon to be in Washington. Yeah, that would that's why I didn't know that existed in some states.
I'm really supportive of that. I'm politically reasonably conservative, and I think non-competes introduce a very artificial restraint of trade into the marketplace. And I actually helped author some legislation here in Oregon that would specifically prohibit non-competes in the healthcare arena, because I just got so offended by seeing people driven out of the state due to non-competes. I don't think they're healthy, and there's nothing confidential. Y'all don't have the recipe for Coca-Cola or something. I mean, you know how to practice medicine the same way I know how to practice law. I'm not harboring a lot of secrets that I don't have to maintain in confidence by virtue of privilege issues.
Right. And we're talking about patient care too. So, I mean, the patient suffers when they can't continue to see you for care.
Yeah. The whole community suffers when we lose providers due to these things.
Right.
Erin, can we just follow up right now and ask the question, what should people who are about to sign contracts or in the next year sign a contract do when that contract has a non-compete?
Yeah.
I feel like right now what we do is we try to argue down the mileage a little bit. We all go onto Google Maps and figure out where would we work. And those of us who don't do that are signing, 2-year, 30-mile or whatever puts us outside of any reasonable place to practice. Those of us who maybe know how to push back a little bit may sign 1 year and maybe we get a 10-mile. But we're all sort of succumbing to feeling like we all feel like we have to sign these things. So I would have my question to Courtney would be, should we push back? I mean, I think that we sign them because we feel like we're going to then not be able to have a job where we want to have a job.
I mean, the thing I don't see people pushing back on sufficiently with regard to non-competes is, well, what if you fire me just because you don't like me that much? And then you're going to tell me you don't want me working for you, but I can't work for anybody else. And I've seen that happen. And so I think it's kind of hard for a practice to justify if we fire you without cause, we will still hold you this non-compete. There's just a fundamental unfairness in that. And I have seen that happen to people, and it's absurd. So when I'm consulting with a physician who has a contract that they're evaluating, that's one of the things I talk about. So the main issues that we see legal disputes arise around is termination provisions, should the person have been fired and what's the consequences of that, and then non-competes. And, I have been surprised at how the medical profession, which again, in my view, has no trade secrets, no real confidential information that they need to protect, as opposed to, say, the software field, where you do see some activity, but they're more reasonable in the software field. And I find that doctors' groups are often a lot more pugnacious and belligerent in the enforcement of these things. Ego seems to get involved, and they seem willing to spend ridiculous amounts that we don't see lawyers fighting over these kinds of things. They realize we're going to waste a lot of money. So I think more and more non-competes have a tendency to go the distance. People are willing to put their money behind these ideas. So to me, if a practice group is saying, we can't budge on this, I would want to know why. I'd probably want my lawyer to work with their lawyer to get some explanation. But if it's just that they're a belligerent group of people that are fairly unyielding about things, I would be thinking, twice, if not thrice, about whether or not I want to go work for this organization.
So would that be fair to say that then when you are getting a job, you get a contract from an potential employer, and you take it to your lawyer and they have a couple points, or you have a couple points that bother you, that you would expect the group then to maybe negotiate? I mean, when we come out, we're sort of trained, like, here's your contract, sign it or go somewhere else.
I mean, I think that if you are a lawyer that has, desirable experience or resume or skills or people skills or whatever it is they want from you, most employers are willing to vary the terms and to offer some concessions. And one thing that I don't see physicians doing enough is pushing back on the front end, whereas I see people in other industries doing that all the time to good outcomes. And so, I mean, at the very least, it will help you to understand what their concern is. Sometimes, especially if it's a hospital, they'll say, well, no, we're neck and neck in competition with this other hospital, and we just can't lose any doctors there, and we don't want them poaching our doctors, and whatever. If that's the issue, then maybe you can at least narrow the non-compete to say, in the event that you part ways, that you won't go work for that big competing organization, but everything else is on the table. So I mean, it's very hard to get another group to make changes to the terms of a contract if you don't know what their goals are and what their purpose is and what their agenda is. And usually a lawyer can either sort of help guide you as to what to ask about to figure that out, or just do it for you.
Yeah. So that was going to be my next question is like, when do you get that lawyer? What's the best way to find a lawyer? Like, let's say you move to, middle of the Midwest, some small town. How do you find that lawyer? Does that lawyer have to be in that same town? Can you help, like, maybe the person coming out of training, with that decision?
Just find someone in the same state. And if you're in a smaller community, you're probably going to find the most competent lawyers in, a larger city. Like, I deal with doctors all over and medical providers all over the state of Oregon, and they tend to get their legal services out of the Portland area. Not always. There's some competent providers elsewhere, but they'd be harder to find. It's a lot easier to find them in in a bigger city. It's really vital that you get to the right lawyer and not to some lawyer that's faking it. You need to be talking to an employment lawyer, ideally, unless you're part of a really complicated corporate transaction. Then you want to be talking to a corporate lawyer, but also an employment lawyer. And here's the problem. Like, if you look for an individual employee lawyer, that's going to usually get you routed to somebody who does discrimination and harassment work, which I do, but they're not going to have a great insight as to what should be in a physician's employment contract. So your best bet is going to be to find someone who knows someone who is just in the legal community. I'd say the bulk of the referrals I get are from doctors who I've worked with before, or from other lawyers who know that our firm just does a lot of this kind of work, but someone who's faking it will not be particularly helpful to you.
I actually wanted to bring up a point here that I have on my questions about. You hear a lot of people say that they need a healthcare attorney when they are going to sign a contract. Yeah. So the difference between an employment attorney, a healthcare attorney, and a corporate attorney. An employment attorney is what we would need for a contract. And that is, you're going to go be an employee of a group, or, you have 2 years to partnership, or one of our traditional setups. You need an employment attorney for that in your state. I do think those people can be really hard to find, and word of mouth is best.
And healthcare attorneys deal with a lot of the regulatory requirements. I mean, healthcare attorneys, though, would be good people to point you to an employment lawyer who would be the right person to help you.
Right. So a healthcare attorney, they're dealing with like HIPAA law and Stark law. So they're not the person to help you with your employment contract. And then a corporate attorney, and Courtney will correct me if I'm wrong, but I've learned all of this from her, so I better not be wrong on it. Corporate attorney is, I'm going to enter into a partnership. I'm going to build an OBL and enter into a partnership, and we're dealing with the 200 pages of contracts that have all of the, there's usually 4 or 5 contracts, and there's pages and pages of detail. And the corporate attorney will help you there when you're dealing with the construction of a corporation.
Yeah, with what the structure of the organization should be. And that's usually more if you're an owner or you're going to be a potential owner. If you're just going to be employed by a hospital or a doctor's group affiliated with a hospital, you just need an employment lawyer. And big firms usually aren't great at being able to provide this service, because we have this elaborate system of legal conflicts. And so a big firm won't want to be in a conflict with, say, the big local hospital. So they can't help you. But again, usually they can refer you to someone who can. Part of why we started doing this work is we felt in the city we live in, there was a real dearth of lawyers who could provide an hour or two of assistance to a professional, or to somebody who's signing an employment contract. It's really fun work, in my view, because you really feel like you've really helped the person and made a real difference in their understanding. But it's short work. It's an hour or two. So getting to the right person is the challenge. But if you find the right person, it shouldn't be that expensive, because they know what they're doing. I mean, most of these, I will get the contract in advance. It usually takes me about 15 minutes to review a contract, even if it's fairly detailed, because there's a lot of similarities and boilerplate in these things. And then I'll spend about 45 minutes doing a consult with a person. Usually they have what they need. Sometimes they want to follow up. They want me to either handle further negotiations or ghostwrite emails or whatever for them, or just, help them with talking points. And that might add an hour or two more onto it. But I mean, I think if you've got a competent person who's not gouging you, you're looking at about an hour of legal work. And for me, that's on the order of $500. Okay. It shouldn't be like some big, massive investment.
Yeah. Cause again, coming out of training, from what I remember, I think I waited until I got an offer, and then I started hunting around, and it was trying to find, the right person, like you guys were just talking about. And, I had no idea what was reasonable to spend. But that sounds about right of what I probably ended up spending.
I think as as soon as you know a community that you may want to move to, I would start looking for leads so that you can get people to run conflict checks. We get these calls all the time where it's like, this person needs this contract reviewed within the next 3 days. Well, I mean, ideally, the lawyer that you're talking to is not just sitting around waiting for your call to come in. They've got a busy life and, other things going on. So I think as soon as you know where you're going to end up, that's the time to just start reaching out. Maybe it's friends from college, friends from medical school who have contacts in that community who can just get you, help you find some names.
Right. And so, Mary, what you were touching on, you were saying basically, if you're buying into something like you or you've been doing, and what the situation I'm in, that I should really be hunting out a corporate lawyer, not necessarily an employment lawyer for that.
Right. And I got my corporate attorney recommendation from Courtney.
Yeah. Okay. Usually the same person will be able to tell you, oh, this person's good with businesses of this nature.
It's just like doctors. Like once you get into a good doctor, you trust their network.
Yeah. So let's get into maybe again for the newer person coming out who this might be their first experience. What are some important pieces to the employment contract, or maybe the partnership track contract? Touch on maybe things like you mentioned termination clauses, non-compete. Is there anything else that could be a pearl or pitfall here?
Yeah. So the first part of every contract, and a contract is just a legally binding agreement, that contains certain conditions that one person will do one thing in exchange for another person doing, or organization doing another thing. And so the most fundamental piece of this is defining the relationship of the physician to the organization and what is that doctor's legal status in relation to the organization. And there's different things that this could be. One would be employee, one would be partner, and one would be independent contractor. So let's just sort of go through these. So employee is the most straightforward. That's going to be a W-2 relationship. You're going to be paid, and the organization's going to do your tax withholding. You're going to be subject to the workers' comp laws if you get injured. You're going to be able to get unemployment benefits if you get fired. And what's also important, and I see two main claims amongst doctors and their employers: age discrimination claims I've seen a fair amount of, and gender and race discrimination claims. So if you're an employee, all of those laws, some of which are federal but also state, you're going to be eligible to pursue claims under those laws. And it seems to me that most doctors these days are working in an employee-employer arrangement, and usually that is spelled out that you are an employee of the organization. How you are described in a contract doesn't necessarily mean that's what you are. For example, I've dealt with physician contracts that describe a doctor as a partner, but they don't really exercise any control in the organization. So as a matter of law, I've argued they're an employee, and when you're firing them, it's age discrimination, for example. Mm-hmm. So it ends up being important if things get, if you get into a lot of real friction. So that's one way to do it. The partner or shareholder in a professional corporation, that's another way. If it's a small group of doctors that are really running the day-to-day and the administrative, and let's say you're a shareholder in a professional corporation, you're also a member of the board of directors, you're also an officer, and you exercise control over it, then that's going to be a different deal. You're not going to be able to avail yourself of the discrimination laws and things like that. There's some downsides to that arrangement. First, all these laws that protect employees don't apply to you if that's how it actually is. You may run a risk of individual or shared liability with the practice. Again, that's why I think it's important to work with a competent person to set up the organization so that you understand fully your risks individual liability. If a practice dissolves, if you're an employee, you just go on your way. If you're, a partner, you may have some rights to, liquidated assets of the organization.
What about debts, though? If the organization
too, that's a problem. Yeah. I mean, I know of one practice group that had a harassing doctor that, over the course of a couple of lawsuits, they paid out over $1 million for this harassing doctor. And, that sometimes those kinds of liabilities just get shared by the partners. And so what I would say is the most important thing if you're buying into a partnership, one of the most important things is that you make sure that organization is insured out the wazoo so that you're not going to be facing individual liability. There's supplemental policies that called employment practices liability insurance policies that organizations can get to cover liability or at least defense costs so that they don't end up getting shared by the doctors. I mean, that's the kind of thing that because I'm a partner in a small law firm, we're very careful about. We've maximized our insurance coverage just so that we don't have to get into our own assets.
Gotcha.
And then sometimes I see people who are being treated as independent contractors. An independent contractor is somebody who is, and this is, I think, the basics of the law in most every state, who is running their own business, and then they coordinate with somebody else to sort of do some delegated work. So the classic example of an independent contractor is the guy that you pay to paint your house. You don't really know what he does. You give him sort of broad instructions about the color and what the timing should be, but you don't get into the details. I don't think that is unless you're doing like home health work or some kind of remote work, that is probably not an accurate description of a relationship of a doctor to a provider, because the doctor's probably using the provider's equipment and acting at their direction. And so if you're in an independent contractor relationship with a healthcare group, I would wonder about whether or not you have a proper understanding of what your relationship is.
Yeah, well, that's good, because I'm a quote unquote independent contractor for diagnostic services, because I read for an imaging center, and they pay me, per click, but and I have a contract with them and everything like that. To me, it seemed like very straightforward and simple, but can you elaborate on what kind of pitfalls there might be in that kind of relationship?
Well, if both the provider and the individual run the risk of, you're not paying the taxes probably that most people are paying, like FICA and FUTA and unemployment benefits and
right.
Whatever your state's doing to you. And if the state or federal taxing authorities look at the arrangement and decide, wait a second, this was an employment arrangement, usually the employer is going to be in more hot water than the employee, but it ends up being a tax issue. I've also had people who are, I can't think of one with physicians, but where somebody gets let go and they go file for uninsurance benefits. And the state realizes, okay, no one's ever made insurance benefits payments for you, and then they coordinate with the taxing authorities to figure out, wait a second, does this person really have employees, but they're characterizing them as independent contractors, thereby denying, the public coffers of these various employment-related taxes.
I think what Courtney's bringing up is that we have independent contractor jobs. I'm possibly starting to cover call at a local hospital, and all that will be kind of our independent contractor like side jobs. But I have learned, I think where Courtney's coming from is that there are actual things that have to be met to be independent contractors versus employees.
Yeah, you usually have to be registered as your own business. I mean, there's all these lists of criteria that you go through. And just because something is a minor part of your work, it may be that it's more properly characterized as part-time employment. But if you have, if you're Dr. Mary Costantino, PC or whatever, that may be a legitimate independent contractor arrangement. Also, you look at things like, are you using your equipment or are you using equipment provided by that healthcare provider? That's a real central thing. For example, getting back to the painter, when someone comes and paints your house, it's not like you say, here's the ladder, here, I got some brushes for you, ran down to Home Depot and got, they bring all their own crap. So it's the same idea regardless of what profession you're looking at.
So, but what would you say if I go into a hospital one day a week, or I go in to cover call, it's their patients, their equipment, their staff, their everything.
I'd have to have a more detailed conversation with you, and I can't give you public advice on the air, Mary, but we can consult about this after.
Well, I'm just saying, I think that's a really typical place where we are told that we have to be independent contractors. And what I've learned is that the person who's telling you, yeah, we'll sign you on as an independent contractor, depending on the type of work you're doing, even if they say you should be an independent contractor, that may not be the right place for you to be by law. So
it's not, that's what people don't seem to understand. Sometimes people are like, but I want to be an independent contractor. And it's like, well, it's not something you choose. You have to look like there's a 20-factor test in Oregon. And so I would want to go down the list of the 20 factors with you. The other thing that I would say is that just because something isn't sort of a to the letter legal arrangement, the second thing you have to evaluate is, well, okay, maybe we're not getting this right, but what's the risk here? Mm-hmm. What is the nature of the risk? And so those are all things to look at. But my broader point is, especially if you're working more than sort of a job here, a job there, if you're working, 40 plus hours a week for an organization, and you're characterized as an independent contractor, that starts to sound really fishy to me, especially if you're subject to their scheduling protocols and stuff like that. Again, with the painter or the plumber or whatever, they kind of come and as we've all had that experience, like they just get it done when they get it done. It's rarely okay, I'll see you at 8 a.m. It just doesn't work that way.
And is that because there are benefits to the employer to have people as an independent contractor, because then they don't have to pay?
Yeah. With physicians, it's not as much as with where we see it like crazy as in the technology industry, where people have got, quote, independent contractors working for them 60 hours a week. And if those people were employees, they'd be getting overtime because they're not exempt from, physicians are exempt under the professional exemption, but it's easy for employers to abuse that classification.
I see.
Termination provisions are key. So anytime you're signing an employment agreement, there's the question of, well, how is this all going to come to an end? It can be an indefinite arrangement, so it can just go on forever until it ends according to whatever the terms are there. It can be a term, so you're presumptively being employed for 3 years, and the term can be renewed by agreement of both parties. So you want to know, is it a set term or is it a renewable term or is it just open-ended? Then why do you get to end the relationship? Obviously, if you're the physician who is on the employee side of it, you want to have as many protections as possible. So that gets into what is cause to terminate. And oftentimes, cause provisions are tied to severance. That's what you want, right? You want it to be, if you are terminated without cause, which is going to be a big fat piece of disruption in your life, you want there to be severance provisions that give you time to get yourself together and go find a new job. So maybe that's 3 months, maybe that's 6 months. If you're a super duper hot shot, maybe that's a year, but that is one thing that is negotiated for. I think more of what I see, especially with people who are not, like nationally renowned or whatever, is probably a 60 to 90 day. And usually there will be a notice provision. So you would get notice 60 to 90 days before termination, and the employer has the opportunity to pay you for the notice period. And that's usually what I see happening as well. So the person gets notice they'll be terminated in 90 days and they're off work immediately, and the employer just pays them for that remaining 90-day period. And one thing I'd say is the time to negotiate those is at the beginning, because at the end, it's a lot, unless, someone's been harassing you or you've got some good discrimination claim, it's a lot harder for you to negotiate for severance at the end, where it's much easier at the beginning and can be a much more easy transition. The other thing that you look at around these kinds of provisions are what are cause. Like, is it cause if you, engage, if you're convicted of a felony or something like that? That would be an example of a very difficult standard to meet. So, what gives the employer cause to fire you is going to be a lot harder for them to get to, and they're going to be more likely to owe you severance. Usually, if there is a cause provision, a consequence of that will mean you can be fired without any severance, and basically under sort of a don't let the door hit you in the rear end kind of a scenario.
Is that what they're doing when they, you hear about like building their case against you? And
yes.
I mean, they're trying to prevent having to pay you the 60 to 90 days.
Yes.
Yeah. And so
and a lot of times it's people with even bigger severances than that. And if you're talking about someone who's making $600,000 a year and they're entitled to 1 year severance, yeah, they're going to start papering. And so what I would do is usually if something is trending towards cause, they have an obligation to give you notice and what's called an opportunity to correct. So notice of the problem, and then you have a certain amount of time to fix it. Mm-hmm. So these are the kinds of things that we look at in the termination provisions. And usually there's one that just says, or any other, conduct deemed by the practice to be a violation of its rules and protocol. And that's the kind of thing I'd usually push back on. Like, okay, well, if he's not parking in the designated space, is that really cause for termination? I mean, it should be a more onerous standard than that. But that's the kind of thing I look at with the termination provisions. And mostly I just try to make sure they're in the line of the mainstream and that the doctor understands there may be consequences to not playing by their particular rules. Then, the non-compete, non-solicitation, we can talk about those separately. Usually in employment, there's some kind of payment provision. With a W-2 employee, oftentimes it's just pretty straightforward. It'll be a base salary and then some bonus, essentially, if the practice meets certain revenue goals or something like that. Some partnership agreements, I get cross-eyed reading the way that they calculate how money is given to people, and it just doesn't make any sense to me. And what I try to make sure is you've just got to make sure it makes sense when you sit down with a CFO and say, how does this actually work? Run some example numbers of, okay, if I do this, I will get what? Make sure that you understand those payment provisions and the compensation provisions, and that it'll make sense. Another thing that I don't see a sufficient amount of scrutiny given to is what kind of indemnification provisions exist. I see contracts all the time where the employer is saying, like, if you commit negligence or violate our rules, doctor, you're going to indemnify us for the costs we incur, relating to, any lawsuit that arises. That's a little crazy. And so what you should be having is that if you're basically acting within the course and scope of your employment, that the employer is saying, we'll indemnify you, i.e., we'll get a lawyer if the practice group is sued and you're sued individually. Because chance of there being a frivolous suit is reasonably high too. So you don't want to make sure you're left holding your own bag.
Can you describe indemnify?
Indemnify just means in the event of a claim and a payment that you get repaid.
So like I'm the doctor, I sue they get rid of me, I sue the employer.
No, you're the doctor for, let's pick a random, Kaiser. You're a doctor for Kaiser. Kaiser gets sued saying you committed malpractice. Let's pretend malpractice insurance doesn't exist. It ends up that there's a lawsuit that costs $300,000, but then they sell it for $15,000. Who should pay for that? You yourself? No. The employer should. And so an indemnification provision just makes clear, that for all these things that have to do with the business, that the business is on the hook in protecting you, because they are far better situated than any individual is. And I find there's too much in the way of omissions of these kinds of very basic things. And I have seen the ones where the group, where we get into some dispute with some, staff member saying, he harassed me or he yelled at me or whatever. And the group is saying to the doctor, well, if she sues, you're going to have to pay the cost of the legal fees. And it results in a lot of division and discord. And the time, again, to negotiate these things is at the front end, not midstream when you're facing a claim.
I mean, it surprises me that if you go to work for somebody, that part of what they would be doing, I mean, it would seem like it was their problem.
One would think. That's why you go to a lawyer and talk about these things.
Okay.
Make sure it's covered. Yeah.
And the other thing that I would say is a lot of these contracts that I see, I think they've been like cut and pasted since 1940. Like they're so bad. There's such a variation in the level of quality in these contracts. And it's very rare that I see one and I think, wow, this is fairly even-handed and well-written and understandable and seems to cover all the bases. That's more the exception than the rule. And so you have to, that's why I would say never take it at face value. Half the time when someone pushes back, and this isn't just in the physician arena, but in every arena, people are like, yeah, we don't even know where we got this contract. Yeah, we're happy to make those changes. So malpractice tail insurance, that's kind of getting into the weeds of physician life, but y'all are familiar with that idea. You want to have some clarity around who's responsible for paying for the tail malpractice coverage. Claims made policy for people who may be listening to this that haven't really worked before. Claims made policies are the most common types of malpractice insurance coverage policies, and they provide coverage for claims that are brought against a doctor for services the doctor provided during the policy was in effect. So when the doctor leaves, that policy may not cover claims brought after the point that the physician leaves. So you purchase tail insurance, which just means it covers anything that comes in after the fact. And if you're someone making a change in a job, the job you're going to may require that you have this tail insurance in place. So if that's the case, then one of the things you might negotiate for with your new employer is that they pay the tail as a condition of, you agreeing to leave and go work for them. But to me, the most fair way to do it is, well, if you fire me, you should pay the tail. If I leave voluntarily, maybe we split the tail. It's in everybody's interest to have that piece of insurance covered. And usually there's there's mechanisms that ensure that it gets covered. Like the employer will say, we'll pay for it. And if you show us evidence that you've paid for it, then we'll reimburse you for it. Something like that.
Yeah. And this comes up, I mean, it seems like it might not be a big deal, but tail insurance, the ones I've looked at, $12,000, $30,000, all depends on how long you've worked somewhere.
It does. I've seen them from $5,000 to 30,000+. Yeah.
So not only do you now suddenly not have a job, but you also have a $30,000 bill. And this is why negotiating the tail coverage is so important. I've also avoided tail by using the same physician insurance, same malpractice carrier for the next job, and then I don't have to get tail.
Yeah.
So how can we make non-competes go away? I know Courtney has.
It's legislative. It's like everything else. It's a legislative deal, and and so in California, they have gotten rid of them, and I think I haven't heard anybody say it's a bad deal because where there are trade secrets and where there are confidentiality things, like let's say you're in a very competitive, let's say aesthetic medicine practice or something, and you have all these tricks and that may be confidential trade secret information. You can still protect that and say, like, if somebody goes to a competing practice and then you see them rolling out the same kind of stuff you do, they're using your trade secrets and you can recover for that. There's all kinds of easy mechanisms to recover for that. Keeping the person sitting on the sidelines doing that, whatever that daily rate work is, that's not a good way to do it. It's a inefficient use of resources in a market. And so I don't like them at all. And I say that, and I try to discourage employers from doing them, because I'm like, is there something more narrow and tailored? Because most people don't have a year of savings sitting around in the bank. So people end up violating them because they don't feel like they have any other option. And then you get into this deal of, are we going to go get a temporary restraining order? It's just a mess. So I prefer for people to use a more narrow and targeted solution to address the issue they're actually concerned about at the front end.
And I feel like, I mean, correct me if I'm wrong, Courtney, but you also probably think about an employer. If you have an employee who doesn't actually want to be there, why would you want them working for your company? And that's one thing I always find amazing. Like, so you have a bunch of people trapped in your company.
Yeah, well, the other thing is there is always a threat of, I'm going to take all the employees who work for me and your best staff, and I'm going to set up shop next door and compete against you, and I'm going to do it better and smarter. So one thing that I think is completely legitimate, and it is oftentimes part of an agreement, is a non-solicitation agreement saying you can't steal our employees. I think that's completely reasonable and valid. Right. And those are much more easy to enforce because judges don't like the sound of that. You know, the other thing that somebody should be thinking of, if they're, in the same vein, as if you're wanting to set up a competing enterprise, you still have fiduciary duties to your current employer. So you can't be whispering to your, good as gold practice assistant, hey, I'm going to go set up this other outfit and I'm going to take you with me. And you can't be doing that. It's a violation of your fiduciary duties to your current employer.
Okay. Yeah. When I was in negotiations for my lab, nobody in my office knew anything that was happening, because you have to act, I think, common sense, and then also knowing lawyers, you really do need to act in like an outstanding citizen type way, because the truth always comes out, and when and where and how things were said becomes really important. And so you shouldn't do things that are unethical, and you'll be okay. I think that's one of the reasons I've done okay, is because I haven't done any like behind the scenes things. And that includes with employees. So you got to keep your big mouth shut a lot.
It's also, if you're looking to if you're a doctor that's looking to make a change, that's a great time to talk to a lawyer about, hey, look at my contract. What might I encounter? And a lawyer will brainstorm with you about, well, what are you worried about? And talk about the areas where you need to use a lot of care.
Yeah, that's very good advice. We kind of touched on this a little bit earlier. So what do you do? And I was kind of in a similar situation. What do you do with the take it or leave it contract?
So when we talked about this a little bit. I mean, there's a lot of bad contracts out there. I just wouldn't treat it as take it or leave it. And a lot of times, depending on how, those are called contracts of adhesion. And as a sophisticated person with an advanced degree who's presumably, this is your first language, a court is going to hold that contract to be enforceable. And the fact that it was presented to you as take it or leave it is very rarely going to give you any wiggle room or any excuse to get out of it. So first of all, you need to assume it's going to be fully enforceable. And then I think you start negotiating. And if they're utterly rigid about it, particularly if it seems abusive or very one-sided, I would really think long and hard about whether you want to get into an arrangement with this outfit. I mean, I think the way people negotiate contracts can tell you a lot about how they will be as people administering that contract and acting in accordance with that contract. And if they're rigid and unfair and don't seem interested in hearing your side of the story, it'll say that. The other thing I'd say is, particularly if you are a somebody more advanced in the profession with experience and desirable qualities and, a good track record, your ability to negotiate changes to a contract is directly related to what you're bringing to the table and how much they need you and how much you need them. And I would say you definitely want to leverage every bit of ground that you've got. And, there's never any harm to asking. That's what, whether it's severance negotiations or whatever, people are always like, well, can I ask for, they've offered me 3 months. Can I ask for more? Why not? It's never like you're going to pull the 3 months off the table and say, boy, aren't you uppity thinking you get more? That never happens. So there's no harm in asking. And that's where I think a savvy employment lawyer will talk with you about, mostly come up with talking points about how you can make them understand that the changes you're asking for are really quite reasonable and that you have good grounds for them and you're not just being greedy.
Yeah, I think that's great advice. I remember back to when I was first, interviewing and getting offers and stuff like that. And I thought it had to be this quick seal the deal thing. I asked for a few things and kind of met in the middle, but I was talking to a buddy of mine who's a urologist, and he negotiated over a period of like 4 or 5 months. And I was like, I didn't know you could do that.
Yeah.
I had no idea that was even, I just thought it was like, oh my God, I got an offer. It's in a town I want to be in. I need to make this happen before somebody else, steals it from me. But I think that in retrospect, it would have been wiser to take a little bit more time.
Yeah. And that's also, I think giving some thought to, well, if you might be with this, if you might be practicing with this group or hospital or whatever for the next 20 years, what matters to you? Like maybe, a week more of vacation time really matters to you or something like that. Or maybe every little detail matters. I don't know. But, that you definitely should understand that this is what you're going to live and die by. And I think sometimes people just kind of think, well, I'm just signing a piece of paper and this is all standard. Like when you buy a home, when you go through that lending process and they're giving you 400 pieces of paper. And I think we all understand that none of this is negotiable, right? These are all from lending institutions and you just got to sign them. That's not the case with these kinds of contracts. So taking the time to make sure you understand every line of it is important. And a good lawyer should be your partner in that venture.
I remember the first contract, I didn't even read. I just looked at the number and signed it and thought, yeah, I have a job.
Yeah,
and,
I know.
I'm amazed what I've gotten
shopping.
away with. Yeah. And I remember in residency, a fellow wanted to negotiate. He was staying in the university and he had to move houses or whatever. And he wanted to negotiate like $1,000 moving fee. And I remember all of us being like, ooh, that's really ballsy. That is really ballsy for you to ask for that. Because the reputation of this particular place was like, here's our contract, take it or leave it. And, enough people wanted to be there and we were all like young. And so we all just took it. And I laugh at that now because I used to think, oh, he's going to get in trouble. They may not give him his job.
Well, and if they didn't, what would that tell you about the place? I mean, that they're so arbitrary and sort of knee jerk that anyone asking for anything is cause to withdraw. I wouldn't want to work for that place.
Right.
And Courtney has a good point. You ask for things and it should go back and forth. And usually the contracts that you're presented with are something that probably nobody has actually really ever looked at, and I've had that personal experience where the employment attorney for the corporation, the company, has been, some mediocre person they hired like a long time ago, and they've just never really changed the contract. So you're actually kind of doing them a favor by pointing out some things on the contract and getting it to where you want to be. And when, like Courtney, I know if I had a contract, I took it to her, maybe we would go back and forth one time and then we'd say, okay, enough is enough. Like, let's everybody get in the room. Or she would call their attorney. I wouldn't be involved. And they would talk in their legal way to get to the bottom of it, to summarize it. So what you're not interested in is multiple go-arounds of this contract around and around and around. Let the lawyers talk, let them battle it out.
It shouldn't be that complicated.
No.
That pretty much wraps it up. Anything else? Any closing remarks by you guys?
No, we're going to go have a cocktail.
Yeah, I know. Well, thanks, guys. I appreciate it.
She's going to make me go for a walk. Okay, fine. We'll go for a walk.
Walk to the bar.
Here today.
All right. Thanks, guys.
Thank you.
Talk to you later.
Have a good evening.
Bye.
Bye.
Bye.